Miss Mogute and Miss Shilwatso.
Yes, Your Honor.
I apologize. We had a problem with my team's account earlier. I was unable to proceed as scheduled. I'm told parties have agreed on mode of proceeding. Ms. Shilwatso?
Yes, Your Honor. We had agreed that we take out the matter. Considering that our witnesses have since left our offices, we can have another hearing date.
Ms. Mogute?
It's confirmed that the left, and then
Cancels the 25th of September to 5. Yes.
It's convenient, Your Honor.
Ms. Shilwatso, you can avail your witnesses on that day.
Yes, Your Honor.
Alex, Pacifica. Right. Where is that one in the file? Paper punch. So this court of the 7th of July this year did arrive at a verdict convicting each of the 3 accused persons of the charges of grievous harm pursuant to section 234 of the Penal Code. The matter is now scheduled for sentencing. This is after the sentence hearing that was conducted in the presence of counsels for the prosecution, for the victim, and counsel for the defense. In mitigation, it is submitted on behalf of the first accused person that he is 37 years old. I do, however, note from the probation officer's report that the information given is that he was born on the 5th of January 1995. And therefore is 27 years old. I don't know which version is true, if he's lying now or if he lied to the probation officer. The second accused person is said to be 51 years old, while the third is said to be 80 years old. They're all said to be first offenders with no official previous criminal records filed in court. The court called for a pre-sentencing report for each of the three accused persons, as well as a victim impact statement, which have since been filed in court. For Alex Maina Ochogo, the first accused person, is said to be 27 years old. While still denying the offense, he pleads for leniency in sentencing. The community views him as a pathological liar, a notorious thief, and a drug addict. The family is said to be associated with witchcraft, and it is believed that the mother is said to have allegedly murdered the husband. I do, however, state that the allegations of witchcraft and murder were not substantiated at trial, and therefore cannot inform sentencing. The community is said to have expressed fear for their children's safety should the first accused person be released. He is said to have dropped out in class 2, whereas the accused is said to be a thief. There is no evidence of previous convictions. The community maintains hostility towards the first accused person and have threatened to lynch him should he be released. There are therefore security concerns should the first accused persons be released. However, this cannot form a basis of sentencing. The probation officer is hesitant to recommend a non-custodial sentence. For Pacifica Ochogo Nyakerario, she said to have dropped out of school at class number 3, and that she had poor parental upbringing. She has 10 children from 2 different marriages, is a peasant farmer and a casual laborer. It is said that her family members have not engaged her since her arrest in December last year. She narrates that she has been labeled as a witch by the community. She is a widow and is said to be addicted to alcohol. Her family considers her as troublesome, violent, and abusive. Similarly, the community has threatened to lynch her in case of her release. And due to the negative perception in the community, the probation officer recommends a custodial sentence. For the third accused person, Royal Nyakerario Mayeka, she is 80 years old, a widow with 4 children. The community attitude towards her is said to be positive, save for the fact that she engages in excessive alcohol and drug abuse. The prosecution has asked the court to make reference to the principles and objectives outlined in the judiciary sentencing policy guidelines. At page 15 thereof, paragraph 4.1, The sentences are imposed to meet the following objectives: retribution, that is to punish the offender for his or her criminal conduct in a just manner; deterrence, to deter the offender from committing a similar offense subsequently, as well as to discourage other people from committing similar offenses; rehabilitation, to enable the offender reform from his criminal disposition and become a law-abiding person; restorative justice, to address the needs arising from criminal conduct such as loss and damages; community protection, to protect the community by incapacitating the offender; denunciation, to communicate the community's condemnation of the criminal conduct. The sentencing policy states at paragraph 4.2 that when carrying out sentencing, all these objectives are geared to in totality, and though in some instances some of the sentences may be in conflict. The policy also sets out the principles of sentencing as proportionality, equality, accountability, participation, respect for human rights, and adherence to domestic and international law. The prosecution submits that the offense herein calls for a sentence that is proportionate to the consequence of the offense, which is maim and total blindness. They call for a deterrent sentence considering the aggravating circumstances of this offense. This is to say that the offenders committed the offense using a dangerous weapon, inflicted serious physical and psychological effect upon the victim and the sister, as well as the key witness who had to watch the commission of the said offense. The offense also targeted a 3-year-old child who is a vulnerable person without any provocation. The offense having been committed by family members who abused their position of care and trust. Parties have referred the court to several decisions of the higher courts when confronted with the question of meting out a maximum sentence to first offenders in instances where there are aggravating circumstances. Both the defense and the prosecution have cited the recent Court of Appeal decision in Julius Kitsao Manyeso versus Republic, which is a Malindi Appeal number 12 of 2021, where the court addressed the issue of life sentences. Learned Counsel Mr. Magara asked the court to consider the operative word under Section 234 of the Penal Code, which uses the word liable, which cannot be considered in a mandatory sense. I'm waiting for you to translate, or you're done. Uses the word liable, anaweza kufungwa. Mr. Magara asked the court to consider a lenient sentence for the 3 accused persons that will ensure that the accused persons are rehabilitated considering their respective ages, their poor family background, and the fact that a harsh sentence would be akin to wiping out an entire generation from the grandmother to the grandson. He also asked the court to consider the time spent in remand and the conduct of the 3 at trial. Council's watching brief for the county government of Kisii, the Law Society of Kenya, and the victim, Mr. Morara, Ms. Ndukire, and Ms. Biaki, all echo the sentiments of Mr. Kaino for the state and call for a stiff and deterrent sentence, considering that the child will never see again. They urge the court to sound a loud sentence that will act in the best interest of the child, as enshrined under Article 53 of the Constitution of Kenya 2010, not only for baby Sagini, but for all children, including the second accused person's children. While Mr. Magara states that a deterrent sentence is called for only in cases where the offense is large scale, and common, Ms. Biaki is of the view that the peculiarity of a child's eyes being gouged out is an offense that should not be heard of again, and therefore the need for a deterrent sentence. I have taken into consideration the submissions offered by counsels, which were indeed insightful and of assistance to the court. I also take into consideration the detailed pre-sentencing reports, together with the social inquiry reports filed by the probation office. This court sat through trial and therefore understands the nature and circumstances of this matter. Section 234 of the Penal Code provides as follows: any person who unlawfully does grievous harm to another is guilty of a felony and is liable to imprisonment for life. The Court of Appeal in Julius Kitsao Manyeso versus Republic recently pronounced itself as follows: we recognize that although the judiciary released policy guidelines in 2016, there are no specific provisions for the sentence of life imprisonment because it is an indefinite sentence. Nevertheless, the court was in agreement with the High Court decision in Jackson Maina Wangoi versus Republic, which found that it is not for the court to define what constitutes a life sentence, or what number of years must be first served by a prisoner on life sentence before they are considered on parole. The court held that this is a function within the realm of the legislature. The court acknowledged that in Kenya and internationally, sentence should not only be used for retribution, but should be used for rehabilitation of the prisoner, as well as the protection of civilians who may be harmed by some prisoners. The court held that a life sentence should not necessarily mean the natural